and took the cops on a high-speed chase. Now, this is going to lead him to some massive time behind bars. So buckle up. Let's get ready.
Thank you, Your Honor. We are back on the record and present in the state of Ohio versus Christopher Greer, case number 24 CR 450. The defendant is in court represented by counsel Eric Levy. It is my understanding that the defendant wishes to withdraw his previously entered plea of not guilty and to plead guilty to the state's offer, which is to plead to count 1, corrupting another with drugs, a felony of the 2nd degree, an amended count 2, again amended to include both victims of the felonious assault in that count, felonious assault, a felony of the 1st degree, count 4, failure to comply with the order or signal of a police officer, a felony of the 3rd degree, and count 6, trafficking in a fentanyl-related compound, a felony of the 3rd degree. In regards to sentencing, there is a agreed joint recommendation for 10 years.
Mr. Levy.
Thank you, Your Honor. May it please the court, that is a correct statement of the plea negotiations. At this time, my client is prepared to make a knowing, voluntary, and intelligent withdrawal of his previously entered plea of not guilty, enter pleas of guilty to the charges as outlined by the state of Ohio. Other than the joint agreed recommended sentence of 10 years, no threats or promises were made to induce this plea. And I should add for the record that I am standing in for Attorney Jay Schlockett.
All right, is that 10 some form of that includes the definite minimum?
That joint 10 would not include the
extension
indefinite
detail?
aggregate maximum,
Okay.
yes.
Is that right, Mr. Levy?
It would not include the maximum. It would, however, and is contemplated to include the mandatory consecutive time on the failure to control.
That is correct.
All right. All right, Mr. Greer, how old are you?
23.
How far did you go through school?
I mean, I'm 32. My bad, Your Honor. I'm 32. I graduated.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the indictment in this case?
Yes.
All right. Did you hear the outline of the charges that counsel has said you're going to plead guilty to?
Yes.
And did you hear there's a joint recommendation of 10 years on this case?
Yes.
All right. Do you have any questions about any of that?
No.
All right. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question or you want to talk some more to Mr. Levy, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, then you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I sentence you to prison.
Yes.
In count 1, corrupting another with drugs, it is a felony of the 2nd degree, and it carries a maximum prison term of 8 months and a maximum fine of $15,000. Do you understand that?
Yes.
You understand that the fine is mandatory and it goes anywhere from $7,500 to $15,000. You understand that?
Yes.
Now, count 1, and I'll discuss this a little bit more in count 2, is what's called a qualifying offense. That means when I sentence you, I'll give you a definite minimum number and then an indefinite maximum number. That indefinite maximum number is 50% of the definite minimum number. Do you understand that?
Yes.
Okay, so for instance, if I gave you 8 years on that, then that would be the definite minimum. If I gave you the maximum on it, it would be the definite minimum up to 12 years. Do you understand that?
Yes.
So in essence, a sentence of 8 to 12 years. Count 2, felonious assault. That's as amended is a felony of the 1st degree. That's also a qualifying offense. So the range of terms is between 3 and a maximum up to 11 years with a maximum fine of $20,000. Do you understand that?
Yes.
And on that case, there is a presumption that a prison sentence should be imposed. And when I sentence you on that case, I will give you a definite minimum term plus an indefinite maximum term as I described it before in count 1. Do you understand that?
Yes.
In that case, there's a presumption of prison. That means that that unless you overcome that presumption at sentencing, then a prison sentence would be imposed. Do you understand that?
Yes.
Count 4, the failure to comply with the order or signal of a police officer is a felony 3, carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Count 6, trafficking a fentanyl-related compound is a felony of the 5th degree with a 12-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
And if you plead guilty to the forfeiture specification in count 6, you are voluntarily giving up those items listed. Do you understand that?
Yes.
All right. The failure to comply in count 4, any prison sentence that's imposed on that would be consecutive to any other prison sentence imposed. Do you understand that?
Yes.
All right. Now, I could give you a consecutive prison sentence. That means one sentence after another for these separate offenses. If I did that, then you would face a maximum definite prison sentence of 23 years, that's as a maximum, up to 28 and a half years as an indefinite maximum. Do you understand that?
Yes.
And the maximum fine is $50,000 on that. Do you understand that?
Yes.
Anything on those penalties, Ms. Alessi?
I believe that covered it, Your Honor.
And is it a 3 to life on count 4's license suspension?
It's actually, yes, it's count 3 to life on the failure to comply, and it's also count 3 to life on the felonious assault because the deadly weapon involved was a motor vehicle.
All right, so there are mandatory license suspensions on count 2. That would be the felonious assault. That's at least 3 years up to your lifetime. Do you understand that?
Yes.
And on count 4 also, it's a 3-year minimum up to lifetime suspension. Do you understand that?
Yes.
Any question about the penalties?
No.
Are you presently on post-release control to the parole authority?
No.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
You understand that upon your release from prison, you will be on post-release control for at least 2 years, up to a maximum of 5 years under the parole authority.
Yes.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If your violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, that you would be eligible for judicial release, but only after the mandatory part of your sentence is complete?
Yes.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
Has anybody promised you anything you'd see for putting guilty? No, just the agree recommended sentence.
No, that's to agree with the recommended sentence
All right.
was.
Now, has anybody promised you what I will sentence you to in this case?
No.
All right, do you understand I don't have to follow the recommendation of either the prosecutor or your lawyer at the time of sentencing?
Yes.
All right, have you had enough time to talk with Mr. Levy and Mr. Schlockett before pleading guilty today?
Yes.
Have they discussed everything about your case and answered all of your questions?
Yes.
And are you satisfied with the advice they've given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
All right, Ms. Alessi, if the case went to trial, what would the evidence show?
If this case proceeded to trial, the state would prove beyond a reasonable doubt that on February 26, 2024, the defendant sold purported heroin to the victim, Daniel Cook Sr., and his friend, Stephanie Taleja. The victim and Ms. Taleja then went to the Willow Lodge in Lake County, Ohio, where they used the drugs that were furnished by the defendant, and as a result of ingesting those drugs, the victim suffered an overdose and died. A toxicology screen that was done at the request of the coroner showed that there was 27.1 nanograms per milliliter of fentanyl in the victim's system. As a result, the Lake County coroner ruled the cause of death as an acute fentanyl intoxication. There were also drugs that were recovered in the hotel room on a nightstand where the victim had overdosed. Those were also sent to the crime lab and tested positive for a fentanyl-related compound, a Schedule II controlled substance. On February 28th of 2024, Willoughby police officers attempted to set up a buy bust in order to identify and apprehend the defendant as the person who had sold those drugs, where they had texted the defendant from Stephanie Taleja's phone. The defendant agreed to sell those drugs and deliver them to Taleja at the Willow Lodge. Later that day, where law enforcement was waiting at the Willow Lodge, the defendant drove a 2022 Toyota Highlander that had been rented by his mother to the Willow Lodge. And when Willoughby Police Department and the Lake County Narcotics Agency attempted to stop and block the defendant's vehicle, their overhead lights were activated at this point. The defendant put his car into reverse and intentionally struck the front of the narcotic Chevy Malibu, and then put the car into drive and intentionally struck the back of a Jeep, of a Marshal Service Jeep Grand Cherokee that was being operated by Charles Crasha. This caused significant damage to both vehicles. The defendant then fled at a high rate of speed, causing a substantial risk of serious physical harm to persons and property. And he fled into Cuyahoga County, where eventually the vehicle crashed into a fire hydrant. The defendant exited the vehicle and fled on foot, hopping into the back of a Honda Civic that appeared to have been waiting for him. Through further investigation, including DNA swabs of the Toyota Highlander, a phone dump of a cell phone recovered in that Highlander, cell tower mapping, and a positive ID from the witnesses that were operating the Honda Civic, they were able to identify the defendant as the driver of that vehicle that fled from the police, and also as the person who had sold drugs to the victim back on the 26th. Thank you.
Thank you. Mr. Levy, anything to add to those facts?
No, Judge.
All right, Mr. Greer, did you hear what Ms. Alessi said that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
Yes?
Yes.
All right, what is your plea to count one, corrupting another with drugs, a felony 2?
Guilty.
What is your plea to the amended count 2 felonious assault, a felony 1?
Guilty.
What's your plea to count 4 failure to comply with the order or signal of a police officer, a felony 3?
Guilty.
What is your plea to count 6 trafficking in a fentanyl-related compound, a felony 5?
Guilty.
And what is your plea to the forfeiture specification to count 6?
Guilty.
All right, Mr. Levy?
Thank you, Your Honor.
I have witnessed the defendant and his attorney sign the written plea of guilty here in open court, and I've signed it as well. May I approach, Your Honor?
All right, Mr. Greer, is this your signature on the written plea of guilty?
Yes.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present with Mr. Levy, advised of all of his rights, made a knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary, will accept his plea of guilty. Find him guilty of count 1, corrupting another with drugs, a felony 2. Amended count 2, felonious assault, a felony 1. Count 4, failure to comply, a felony 3. Count 6, trafficking a fentanyl-related compound, a felony 5, and the specification. I'll refer this for a pre-sentence report and victim impact statements. Sentencing will be March 18, 1 p.m. Bond is revoked. Anything else, Ms. Alessi?
No, Your Honor, thank you.
Mr. Levy?
No, Judge, thank you.
All right, we're adjourned.